Hi, I'm here to do a special CommLawClarified today on one of the many Supreme Court decisions that were issued on June 24th, 2019. In particular, this one is Food Marketing Institute versus Argus Leader, and it involves Exemption 4 to the Federal Freedom of Information Act. In fact, this is the first time that the Supreme Court has ever addressed the breadth of this exemption in a court case. What happened here was the Argus Leader was seeking information relating to the SNAP program, which some of us commonly refer to as food stamps. What they wanted to know were the names and addresses of all stores participating in the federal food stamp program and the amount of retail sales per store under that program. The USDA said they would give out the first, the names and addresses, but not the second, because it fell under one of the two things that could be withheld under Exemption 4. The first is trade secrets. That didn't apply here. The second, and what the USDA did apply, was the idea that these were commercial or financial information obtained from a person that are privileged or confidential in nature, and specifically that the amounts of retail sales are confidential information privileged in nature. The paper sued and won in district court, at which point the USDA actually backed off and didn't take the case further. The Food Marketing Institute stepped in and decided to appeal this decision to the United States Court of Appeals for the Eighth Circuit, which ruled again in the paper's favor. The case goes to the United States Supreme Court, which in a decision on a 6-3 decision written by Justice Gorsuch, overturned both lower courts and said that Exemption 4 does allow for the withholding of this information. There were actually two issues in the case. The first was what we call a standing issue. Could the Food Marketing Institute even come in and appeal this case? The court said yes. There are two instances, or two factors that must be met when a private entity wants to take the place of the government for standing purposes here. One, is there an actual or imminent injury that is fairly traceable to the judgment below? And two, could be redressed by a favorable ruling. The court said yes to both of these. Then it got to the merits of the case. And it noted that that FOIA does not actually define the word confidential. So in looking at how Exemption 4 applies, Justice Gorsuch said that you have to look at the ordinary common meaning when Congress enacted the FOIA in 1966 as to what confidential means. And he said it specifically means something that's private or secret, okay? Although the Argus Leader said it also must involve a substantial harm that would result from the disclosure of the information, Justice Gorsuch said this did not apply. That was something that might have been found in legislative history around the time of the act, but the ordinary plain language and statutory language of FOIA itself, specifically Exemption 4, does not require that there be a substantial harm flowing from the disclosure of this information. And he said we cannot approve such a casual disregard of the rules of statutory interpretation. In dissent, Justice Breyer, writing for 3 justices, actually went the other way. He didn't say they should find a substantial harm necessarily, but did say that more than a competitive harm, somewhat of a general harm could be considered in whether the USDA or other agencies could release information through the Federal Freedom of Information Act. He also said that releasing this information would be consistent with the purposes of the Federal Freedom of Information Act, as the whole point of FOIA is to give public access to information it cannot otherwise obtain. So the fact that private actors have customarily and actually treated commercial information as secret cannot be enough to justify non-disclosure. Now, how might this matter to you, the readers of CommLaw Blog? And I am planning to do, by the way, a blog post on this in the future that goes into all this in more detail. Well, I'd say there's maybe 3 or 4 things you should be thinking about. Number one, it is important for corporate clients because many corporations use the Federal Freedom of Information Act to find out information about competitors or have to understand that people are trying to find out things about them. So this falls squarely into something you need to be worried about. Second, the statutory interpretation argument that you look at the plain language of the statute and the plain language alone does skew very narrow. It's actually an accepted practice by many justices, in fact, many conservative justices. So it gives an idea as to where the court may go with other statutes in the future when it looks at interpreting statutory language. And finally, for my purposes, and full disclosure, 2 of my clients joined an amicus brief supporting the Argus Leader in this case, the American Society of News Editors and the Association of Alternative News Media. I think that it takes a very narrow and dangerous view of the Federal Freedom of Information Act. The narrow construction saying that exemptions are to be equated to disclosure, I think is wrong. I think it's not what FOIA means, and I think it's dangerous. And I do think that the court put too much weight in the government's assurance, the USDA's assurance, that it would withhold information under this statute unless it was actually forced to release that information. Again, a narrow view, one that's inconsistent with FOIA, and unfortunately may carry the day. So keep an eye out for my actual written blog post on this in the near future.